Hello, everyone. In behalf of the NBSAP Forum, I want to welcome you all to this session. I am Diego Ochoa, NBSAP Forum Communications Advisor. On behalf of Christina Soppels, I would like to thank you all for attending our March webinar series dedicated to legal preparedness for implementing NBSAPs. The second webinar in this series is about establishing enabled legal conditions to implement NBSAPs, presented by Dr. Balakrishna Pisupati from Transdisciplinary University and Mr. Tamkin Mobegi from UN Environment Program. Laws have the ability to catalyze prompt, focused, and coordinated actions to mainstream biodiversity values across sectors and society. Given pressures on terrestrial and marine environments, countries are encouraged to develop legal frameworks that effectively facilitate the implementation of the Convention on Biological Diversity. NBSAPs are the key conduit for implementing the CBD's strategic plan for biodiversity and are a central policy-making tool for national biodiversity management. This March, the NBSAP Forum is hosting a four-part webinar series to support countries to legally prepare themselves to implement NBSAPs. Article 6 of the Convention on Biological Diversity requires parties to develop national strategies, plans, or programs which should reflect the measures set out in the Convention. Parties have developed NBSAPs, which translate the measures set out by the CBD and other biodiversity-related conventions into a set of prioritized country-specific national actions. NBSAPs may also set out legislative actions at national level. During this webinar, Dr. Bala and Mr. Mobegi will provide you options to improve the legal effectiveness of NBSAPs and enhance your understanding of the associated legal elements. They will also outline the level of legal preparedness countries need to undertake to be able to achieve the Aichi Biodiversity Targets. Dr. Balakrishna Pisupati has more than 26 years of experience working with biodiversity, law, policy, and development issues. He is currently the Vice Chancellor of Transdisciplinary University based in Bengaluru, India. Dr. Bala previously worked with the UN Environment in Nairobi, where he coordinated actions related to biodiversity multilateral environmental agreements. Tamkin Mobegi is Program Assistant for Multilateral Environmental Agreements, Support and Cooperations and the UN Environment Law Divisions. He supports MEA implementation through projects, research, reporting, and enhancing cooperation and synergies between stakeholders. Welcome, Dr. Bala and Mr. Mobegi, and thank you for attending this invitation. It's a real pleasure to have you here today. As usual,
thank you very much.
As usual, before starting, I just want to remind you all some rules and our dynamics in the NBSAP Forum webinar. Microphones will be muted during the presentation. This reduces interferences and facilitates the communication. We will have a 1-hour presentation followed by 30 minutes of questions and discussion. Please send us in advance your questions or raise your hand in the control panel of GoToWebinar. If you want to speak and the connection allows, we will open the participants' microphones to promote interaction during our Q&A session. As many of our participants are not English native speakers, me included, I would like to remind our speakers the importance to talk slower. This fosters the comprehension among our practitioners. This session is being recorded as usual, and it will be available at the NBSAP Forum website. All the participants will receive an email with a link to watch it, as well as a PDF copy of the presentation and a list of resources related to the topic. Now, I will transfer the webinar to Dr. Bala and Mr. Mobegi. Please enjoy sessions, and thank you very much again, Dr. Bala, for this session.
Thank you very much, Diego, and very good morning, good afternoon, good evening, colleagues who are joining us from various parts of the globe for this webinar series, and I'd like to add my words of appreciation as well as thanks to all of you for joining us at this particular session. And as Diego was mentioning, we are splitting the presentation into two parts, where I'll be providing a bit of an overview of the issue of legal conditions and legal preparedness to deal with the national biodiversity strategies and action plans. And my colleague Tom Keane would be joining us from Nairobi, where he will be making a presentation on a few specifics in terms of how the legal conditions could enable countries to deal with the realization of the Aichi Biodiversity Targets. More specifically, we would like to present you a few examples of target-specific legal components. But before I start, let me quickly remind all of us on the importance of the national biodiversity strategies and action plans. For those of you who follow the Convention on Biological Diversity, we're all familiar with Article 6 of the Convention that encourages countries to have the national biodiversity strategies and action plans put in place. Article 6A of the Convention and Article 6B of the Convention requests countries to mainstream biodiversity across different sectors. So certainly this particular article of the Convention is the heart of ensuring not only planning for purposes of realizing the objectives of the Convention, but also essentially to serve as a tool for looking at how countries implement the objectives as well as look at the compliance mechanisms as well. But for those of us who actually are following the Convention process and also the iterations of the national biodiversity strategies and action plans, we all recognize that countries are at various stages of not only developing and implementing the NBSAPs, but also trying to adjust, trying to realign the NBSAPs to the global objectives, both the strategic plan of the Convention 2011 to 2020, as well as the 20 Aichi Biodiversity Targets. And before we get into the targets and the NBSAPs and the strategic plan, which actually is guiding the NBSAP process and the revision that seems to be just concluding with more or less most of the countries who are parties to the Convention have completed the updating, revision, or revising their NBSAPs. A few points need to be considered before we get into the details of the discussion. First, we actually have seen a revision, updating, and review process that is just concluding. Even though, as per the decision of COP10 in Nagoya in 2010, countries should have completed the process in 2015. There have been some delays for countries, and we have more or less all the parties who actually have submitted their NBSAPs. That is a very, very good and important news. But when UNEP, when I was working in UNEP, we undertook an interim assessment of where countries are with respect to their NBSAP revision process, not just in terms of the process of developing the NBSAP, but what are the key contents of the revised or updated NBSAPs, a study that was done in 2014 and presented at the 19th meeting of the Subsidiary Body on Scientific, Technical and Technological Advice, SubSTA meeting in 2014. A few points were very, very clear to us. First, countries who actually have updated their NBSAPs at that point, I'm talking about 2014, mid-2014 to be precise, countries still actually were finding it difficult to deal with cross-cutting issues such as access and benefit sharing, financing, mainstreaming, where the information that was provided in the updated or revised NBSAPs were a little scanty in terms of us trying to understand what countries have learned in terms of implementing the conventions in 1993, 1994, when the implementation started, honestly, when the convention had come into force. So we published the interim report, and then in the next few weeks, we also are publishing a full assessment of the updated, revised, and reviewed NBSAPs, where I'm authoring the particular paper with one of my colleagues from Fletcher Nansen Institute, Mr. Christian Pritt, where we did an assessment of the NBSAPs in terms of what are the gaps where countries have actually done very well with respect to looking at mainstreaming issues of biodiversity across sectors, which, as you know, was one of the key elements of consideration for the last COP meeting in Cancun, but also what are the lessons that countries have actually learned from the first generation of NBSAPs that they have considered for putting into the revised or updated NBSAPs. And of course, the results do indicate that there are countries who actually have actively considered their implementation experiences while revising or updating NBSAPs. But still, we have challenges of countries who still are unable to look at effectively dealing with cross-cutting issues, dealing with some of the sectoral issues that are related to the convention on biological diversity. That is a bit of a concern for all of us, essentially when we are looking at 20 plus years of the convention coming into force. The second element, which also is very important for us to consider, is that even though countries have just concluded their updating and the revision process of NBSAPs, countries may not have an opportunity to do the same for the next several years. But this comment I'm making in the context of we having about 2 years before the strategic plan of the convention is going to be completed, and we will be soon discussing, perhaps in 2018 onwards, during the next COP14 onwards, on what should be the next iteration of the strategic plan for the convention post 2020, but also what would be the nature and the kind of targets that countries would be setting for themselves in terms of the global biodiversity targets post 2020. And this is very, very important, not only in the context of the NBSAP discussion we are having, but it is also important in the context of several other processes that are parallelly running in support of conservation action, ranging from the Sendai framework on disaster risk reduction to the Addis Ababa framework on financing for development, to the sustainable development goals that were adopted and being implemented in countries. So there are lots of other iterations that need to find a place as and when we are discussing the NBSAPs. And lastly and importantly, even though countries decided that given the specific or special nature and conditions of country-specific capacities, resources, abilities to deal with biodiversity conservation action at national level, the key lesson that we have learned, or the key signal we have received from the revised updated NBSAP process, including the 5th national reports, is that countries have set for themselves in terms of looking at the national biodiversity targets. Very good decision as far as the parties are concerned, so that the targets are much more driven by national circumstances, guided by the global principles of Aichi. But the resulting element of it is that currently we are looking at more than 2,000 plus targets collectively put together just for biodiversity that are somewhere related to the Aichi biodiversity targets. So the key challenge for those. Yes.
Dr. Bala, sorry for interrupt you, but I think we are having some issues with the presentation because I cannot see it at this point. Sorry for the audience. Can you check out again?
Is it okay now?
Yes, it is charging now. Let me check out. So sorry. Yes, we are just seeing your first slide. I don't know if you can check if.
Correct. Correct.
Okay, that's perfect. So sorry. Okay, go ahead. I'm sorry for interrupt you.
Yeah. No problem. So the last point I mentioned was that the number of national targets that will need to align themselves for the Aichi biodiversity targets at the global level. So with that, let me get on to this particular presentation that is going to be looking at the elements of legal preparedness, or our ability to deal with the legal elements in relation to the targets. I'm just trying to get my audio panel off. Okay, hope you can see the slide there. Okay, so this actually is a very popular quote from Justice Paul Stein, where he said almost all nations, including developing ones, have basic environmental protection laws in place. But whether they are developed or developing, an enormous gap exists between and what is actually happening on the ground. So certainly there is a bit of a disconnect between to deal with biodiversity or NBSAPs, but also how the legal preparedness can translate into action on the ground. So, with that perspective, of course, I'll quickly skip this slide, just to mention only one point, that even though countries have revised and updated and submitted their revised NBSAPs to the Secretariat of CBD, essentially one key element is that the NBSAPs are always a living document. So, which means that it has to be periodically revised and updated. It has to be made more relevant and up to date with respect to the national conditions as well as the international obligations that countries have in terms of biodiversity conservation, but also to other sectoral elements as well. So the moment we are talking of legal preparedness and NBSAPs, what are the key elements or the issues that one should be looking at? First, the NBSAPs guide biodiversity action at the national level, but to a large extent, NBSAPs are not legal documents. So there are more policy documents, there are more guidance documents. And the key opportunity there is that countries will have an opportunity to update them and revise them as and when it is required, even though very few countries are able to do it. But essentially not being legal also provides a major challenge in implementation, because sectors and other stakeholders who should be looking at the elements of NBSAP for their actions related to biodiversity may not necessarily take the elements or the components of NBSAPs very seriously. But countries earnestly invest a lot of time and resources in making sure all the participating stakeholders do have an ownership in terms of the elements of the NBSAP. But essentially, the information that we are looking at from the national reports that are being presented, the ownership is still wanting, and we still do not have sectors or ministries who are actually owning the elements. And one of the key comments that generally are made by stakeholders is that because NBSAP is not a legal document, essentially it is more seen as a guidance document, so not necessarily stakeholders need to take it much more seriously. That's first part of it. The second part of it is that even though in itself it's not a legal document, almost all the countries consider developing based on series of legal instruments and legal provisions that are already available in countries. There is no one NBSAP that does not consider the sectoral laws, sectoral legal and regulatory mechanisms that are in place, whether they are related to forestry, whether they are related to fisheries, whether they are related to tourism, they are related to agriculture. Large part of NBSAP, the base of NBSAP always has been what is the current legal and regulatory mechanism that is existing in the country and what needs to be done better to deal with biodiversity obligations under the convention. But the only missing gap that exists is that even though we have the sectoral policies and legal frameworks, we have very few countries that have dedicated, specially designed legal frameworks related to biodiversity in general, as it is seen with the objectives of the convention. There are very few countries like India who actually have developed a Biodiversity Act as early as 2002 in terms of considering the objectives of CBD as a framework for having a national legal framework on biodiversity. But even though India has a Biodiversity Act, to a large extent, the NBSAP is always developed, revised, independent of the Act. And that is also a concern for a lot of people looking at the legal preparedness for countries, because you can't have a legal instrument like a biodiversity law and an NBSAP document which is independently seen only as a policy guidance tool. There you still will have the challenges and the gaps that I mentioned a couple of minutes. But if that be the case, how can we provide legal certainty for NBSAPs? How can we sort of have the legal certainty to NBSAPs that can help implementation of NBSAPs better? First, giving a bit of legal certainty to the NBSAPs and its elements provides a lot better prioritization for sectors and ministries and stakeholders for mainstreaming biodiversity. And that national prioritization will definitely be much more stronger if there is legal certainty to the elements of the NBSAP or to the NBSAP in itself. Second, it enshrines biodiversity principles in decision making. So no longer it is a document that is developed by Ministry of Environment and Forest with some participation of different ministries, but because it has a legal certainty, legal elements provided to its implementation, where stakeholders are bound or obliged to look at prioritization in decision making for sectoral implementation, it helps better implementation of NBSAPs. It also sets legal basis for biodiversity policy and planning across sectors and levels of government, because a large number of governments, as and when they were revising or updating the NBSAPs, one thing which is extremely quite clear is that many countries, which they did not do in the first round of the NBSAPs, which they did in the second iteration of the NBSAPs, have been to decentralize implementation of the NBSAPs by having more provincial and regional ministries and regional stakeholders to take ownership of the implementation and also get them involved in setting up the prioritization when revising the NBSAPs. And that is a very positive move, in terms of decentralized implementation of NBSAPs at different levels as well. And having legal certainty helps these kinds of institutions at different levels, provincial and regional levels, to do action much better and more clearly, including setting finances, including prioritization. But also having legal certainty sets out clear mandates for cross-cutting institutions, biodiversity institutions that actually need not be mainstream ministries like environment, like agriculture or forestry or fisheries, but also ministries that are that have a very, very important role in terms of biodiversity conservation, like health, rural development, tourism, women's development. So a lot of these ministries, cross-cutting biodiversity issues are very, very important for them. And that is why having certain level of legal certainty to the NBSAP will help these ministries to implement the NBSAPs much better. It also builds stakeholder confidence in the new process and incentives, because many countries having an updated NBSAP and the process that went on in updating the NBSAP ends as soon as an NBSAP has been updated and provided and submitted to the Secretariat. A lot of countries continue to have stakeholder participation, dialogues and discussions and implementation reviews, but to a large extent countries still are finding it difficult to continue that kind of a participatory process in terms of stakeholder involvement. And to a certain extent, having a legal certainty will also help the stakeholders not only to participate but also look at what will be their role in terms of questioning the implementation as well. It also recognizes community rights and customary law, because for many countries these are important issues in the developing world, especially those the countries that are rich in biodiversity, whether it is in Africa or Asia or Latin America. But having a legal certainty to NBSAPs provides the elements of recognizing both community rights and customary laws. And lastly and importantly, it builds equity, justice and fairness into the process and the outcomes of the process as well. So that's actually the context within which we are discussing the legal certainty with respect to NBSAPs. But then you may ask, why is it we are discussing legal preparedness? Because legal preparedness helps countries to assess the reform and implement laws to achieve NBSAP targets. If you look at the discussions that generally go on in developing or revising an NBSAP, it is more to look at what is the sectoral law of fisheries saying with respect to biodiversity. So let's bring some elements of it into the NBSAP so that the NBSAP is linked to that particular sectoral law. I think it's also important for countries to look at not only that we are picking up signals and sound bites from different sectoral laws and policies, but we also need to close the loop by providing NBSAPs to also help those sectoral laws to be revised, to be reformed, and to be implemented better. Because if that kind of a two-way process is not going to be put in place, most of our discussions, whether it is related to the effectiveness of NBSAP or whether it is related to mainstreaming in biodiversity, will only be on paper to the extent that the laws and policies would guide some elements of the NBSAP, but the NBSAP implementation may not necessarily influence the reform or the implementation of the sectoral laws that actually guide the development and implementation of the NBSAPs in general. The second part of it, the enabling NBSAPs legal framework, includes legislation, regulations, and policy, but it also defines institutional arrangements much better, because that is also a major challenge that countries face when it comes to implementation of NBSAPs, especially those issues that are cross-cutting in nature, those issues related to mainstreaming biodiversity and things. And also the regulatory mechanisms that includes command and control, the incentives, the voluntary or participatory approaches, permits, certification standards, compliance and enforcement mechanisms. See, all of it actually in one way or another are impacted or influenced on how the country's NBSAP is framed, how the country's NBSAP is seen in terms of it being a document that not only looks at setting a national policy, but also guides the national legal preparedness to deliver on the biodiversity agenda, both at the level of the convention at the global level as well as at the national level in terms of the national targets and the national action plans. But then how do we prepare for it? How do we prepare for doing it? First, financing mechanisms that are integrated into laws or policies to ensure effective and long-term implementation. This has been a major challenge for countries, and in the revision and the assessment that we are concluding, which will be published in the next few weeks, one point that came very, very strong and clear from most of the NBSAPs that are already submitted to the CBD Secretariat. The biggest challenge countries are facing is in relation to having a financial framework, a financial plan for implementing the provisions of the NBSAPs. And to a large extent, the financing element is a challenge because it is not properly guided by the legal requirement of sectoral agencies and ministries in terms of their obligations for implementation. To a large extent, sectoral agencies and ministries are given responsibilities for implementing certain provisions of the NBSAPs or realizing certain national targets. But then, because the framework, because the action plan or the strategy is only a policy document, the kind of requirement in terms of institutional support and financing that are required to realize those objectives or those elements of their mainstreaming components are always the weakest point. The second point is a strong legal institutional structure with the power to govern implementation and the ability to leverage sanctions or penalties to encourage compliance will definitely be not there if there is no legal element or legal certainty in NBSAP. Again, people will see that as a kind of a policy document, as a guiding document, so nobody is really knowing what will happen if they apply the provisions of it. And to a large extent, still this is a challenge because even today, NBSAPs are the documents that are owned by the ministry. The responsibility of compliance, responsibility of encouraging implementation is only lying with one particular ministry, which to a large extent is challenged by capacity, challenged by finances, and also challenged by the oversight in terms of the importance of the ministry within the overall framework of the government as such. The third point, procedures for review, revision, and refinement based on the collection of relevant information pertaining to the NBSAP implementation is also very, very important because of the points that I mentioned before in terms of not only looking at sectoral laws, but also NBSAP implementation. Helping the revision of sectoral laws is also something which can be better done if there is legal certainty. And the fourth point is that unless we also have certain legal elements put into that, public participation among stakeholders for giving considerations to the goals of the to the strategic plan as well as the Aichi Biodiversity Targets will be definitely a challenge, even though we only have a window of another 2 to 3 years for achieving both the strategic plan objectives as well as the Aichi Biodiversity Targets. So if you're going to be looking at with that background in terms of NBSAPs and legal preparedness, the table actually provides you some elements which summarizes some of the points. Designing aspect of the law and why do we have to look at legal preparedness. If you're going to look at the operation of different biodiversity conservation laws, sectoral laws, fisheries law, forestry law, agricultural law, Wildlife Protection Act, Environment Protection Act, whatever they are, the legal preparedness determines how laws and institutions work. It identifies the strengths and weakness of existing laws and the principles that might guide conservation action and conservation agents. It also incentivizes the incentives and structures for encouraging good early decisions in terms of biodiversity action. The legal preparedness ensures that law and institutions apply and operate in resolving and preventing disputes, which currently majority of NBSAPs do not necessarily consider or have provisions of. It enables relevant stakeholders to take appropriate legal action. Currently, it's only some element of policy action, but there is hardly any legal action that is used in NBSAPs in many countries. It examines cases and judicial actions at different stages, and it improves the understanding of system users, including what may deter them from taking action and what may incentivize from taking action. In terms of access to justice, it contributes to legal empowerment and establishes clear justice systems. It dictates what happens to stakeholders who do not have access to formal legal systems. It also defines the role of non-legally qualified intermediaries, because as we know, implementation of the elements of NBSAPs is just not about ministries and agencies that are related to government, but we also have several intermediaries who are very, very important stakeholders in terms of implementing the NBSAP. And lastly, when it comes to enforcement and outcomes, the legal preparedness determines the implementation of decisions from court tribunals and other relevant mechanisms. It also expands institutional options for improving enforcement and compliance. So that's part of the presentation that I was planning to make. And if Tom Kim is online, maybe I'll invite him to take over from the next slide.
Good afternoon, colleagues and friends from the other side. This is Mobegi from Nairobi, and I'm going to present on the enabling legal conditions for not only implementing the NBSAPs, but also implementing the Aichi targets and delivering on the 20 Aichi targets as adopted in 2010 under decision, COP10 decision 2. As you can recall, the best background to the documents, to the Aichi targets, is that these are 20 targets on the adopted under the 2010 Strategic Plan for Biodiversity. And under this plan, countries, partners, and scholars, including academic scholars and other stakeholders, have been called upon to contribute to the realization and implementation of these development goals under four strategic categories. The linkages between the Aichi targets and the NBSAPs have already been clearly established by various articles published by the CPD and other stakeholders, including UN Environment and the International Development Law Organization. The four strategic goals include strategic goal 1 on addressing the underlying causes of biodiversity loss, which has target 1 to target 4, reducing pressure on biodiversity strategic goal B, which covers targets 5 to 10, and improving the status of biodiversity, which covers target 11 to 13, and enhancing the benefits of enhancing the conservation of biodiversity for the benefit of all under target 14 to 16 and target 17 to 20 on enhancing the implementation of the Aichi targets through the participatory planning processes, knowledge management, and capacity building. From each of these strategic categories, I will cover one target from each category, and the issues that we'll discuss will be reflected, as you will see from the documents that were submitted separately, will largely be copied in implementing the other targets. And here I will discuss the necessary legal actions that can be taken specifically at the national levels to fasten the implementation process of not only the Aichi targets, but also the NBSAPs. As you can see on your screen right now is that why we need to focus on the law within the Aichi target process is that it has an essential role to play, a central role to play in the process, because laws cover a wider aspect of implementation processes, starting with the constitutions, national legislations, institutional settings, governance systems and financing mechanisms, accountability frameworks and frameworks for accessing information, are all of them largely in almost all countries established under specific legal frameworks. And targets and considerations for non-conservation legal tools under the Aichi targets can include land use planning and development control laws, sustainable use laws in agriculture, fisheries, forestry, and water management programs, laws on public finance, economic incentives and disincentives for the implementation of the Aichi targets, innovative market frameworks and mechanisms. So on to the next slide. Yes. So we will go straight into covering target 1 under the 20 Aichi target, which specifically covers that by 2020, all people are aware of the value of biodiversity and steps taken in its conservation. Here under, we will see that on your screen, you will see that related legal actions will contribute to the collection and updating of biodiversity information, contribute to mandatory public participation, including sharing of information, setting of timelines, costs for accessing the information, especially where each certain information is given a price tag, reporting requirements, and procedures for submitting complaints and appeals to any decision that is being made in this regard. The laws will also facilitate the adequate flow of information, including information on country-specific plans, actions to be taken, results achieved, and further way forward, pointing on into the future. This will also include public participatory procedures, which will contribute to the realization of strategic goal E, as we will discuss further ahead in this presentation. Public participation procedures will also be set out in constitutions and legislations, and besides that, it can also be included in institutional specific frameworks such as institutional constitutions or institutional programs of work. And to a larger extent, laws under this target will contribute to eliminating conflict of laws and reduce confusion among stakeholders as to which law is really applicable in this regard, thus contributing to transparency and openness. On to the next slide. In this slide and under this category on reducing direct pressures on biodiversity, I'm going to discuss target 5, and whatever we are discussing will be copied on to the other targets. So under this category, we'll see that the rate on the loss of natural habitats, and including forest, is at least halved, and where feasible, brought close to zero, and degradation and fragmentation is significantly reduced by 2020. To do this, the laws can contribute to the establishment of appropriate institution and governance arrangements that promote accountability. Next is that the law will contribute to aligning the economic incentives for reducing the rate of biodiversity loss, including incentives on compliance mechanisms and national reporting requirements. Number 3 is that the law will facilitate the empowerment of certain groups, including poor people, women, indigenous communities who are particularly dependent on ecosystem services and are disproportionately harmed whenever the degradation process is not controlled. This example of this approach has been provided under the Indian Tribes and Other Forest Dwellers Act, and this is an example of a legal instrument that can be copied or good practices borrowed from by other countries. On to the next point is that the law will help establish procedures for developing indicators that may be useful for tracking or monitoring the status of an ecosystem with defined thresholds and targets that will represent a desired level of healthy for the ecosystems. And laws in this regard will include national planning laws and healthy laws, especially those ones on spatial planning and urban planning. It will also contribute to the development of restoration and maintenance programs, the introduction of the permit system for those who wish to engage in the commercialization of biodiversity, such as prospecting and involvement in the use of indigenous biological resources and the exporting of indigenous biological resources or bioprospecting products and research products. Further ahead, the law will contribute to the establishment of protected areas, including coastal marine areas, and establishment of sanctions such as fines and other legal sanctions for those who are involved in encroaching into forest areas. In the category on improving the status of biodiversity globally, I covered target 12 in that regard. And as you can see, is that legislation can be used to achieve the following: increase incentives for private landowners to participate in land stewardship, to regulate habitat conservation plans, to provide the protection needed to prevent the extinction of endangered species, establish minimum protection standards, and facilitate provision of technical assistance to local units of governments in identifying sensitive habitats, methods of protection, and the review of local plans where the state has identified certain endangered species or their habitats during the early stages of any planning process. Further, the law will contribute to facilitating the evaluation of the compatibility of various land use practices, including and specifically practices surrounding natural systems and areas that need to be specifically protected. And lastly, law will contribute to establishing measures for balancing recreational opportunities and a balance in other human activities as relates to the enjoyment of the environment and biodiversity. And lastly, in the strategic goal D on enhancing the benefits of biodiversity for all ecosystems, I will specifically cover target 14, which provides that by 2020, ecosystems that provide essential services, including services related to water, and in that regard contributing to healthy livelihoods and well-being, are restored and safeguarded. And in the process, this should take into account the needs of women, indigenous and local communities, and the poor and the vulnerable groups. In this process, on the next part of the slide, you will be able to see that legislation can be used to achieve the following, but this is not limited to only these achievements, which include promoting access to services, including legal redress, services, complaint channels, and this will finally contribute to the effective assertion of any right that has been violated. Secondly, it will provide a set of systems that will facilitate the flow of relevant information from one level to another and knowledge from one level to another. And this will empower the people to be establish principles and guidelines on the special needs of women and other groups in the society as far as biodiversity conservation and implementation of Target 14 is concerned. Next is that it can help establish effective remedies and compensatory procedures for anyone whose rights have been violated as a result of the utilization of biodiversity resources. And lastly, it can contribute to the establishment of policies to relating to ecosystem services, including contributing to the identification of gaps, as Balakrishna discussed earlier on, relating to the protection of persons and groups of concern. And that marks the end of our presentation in this regard, and I hand you over to Bala for further comments.
Okay, thank you, Tonkin. Actually, what Tonkin gave you is a bit of a flavor in terms of how the different Aichi targets can be tagged in terms of specific legal actions or legal measures that can be considered as a part of ensuring preparedness for countries to deal with better implementation of the NBSAPs. But let me just give the following as my concluding remarks. First, countries have already revised and updated the NBSAPs that are already submitted to the convention. So these NBSAPs are the ones that are going to be staying with countries for a few more years to come. But what countries need to understand is that even though resources or finances may not be available for countries to do a full-fledged updating and revision for the next several years because of resource constraints, but countries actually should be encouraged or need to be encouraged by themselves in terms of self-motivation to keep the NBSAPs as a living document. So as and when an opportunity arises of using the elements of the strategy and action plan for either fine-tuning a legal instrument that is already available or coming up with an element of legal tool that can be used to more effectively implement the NBSAPs, countries should consider it actively as much as possible. The second point is that currently, in the next 2 years, we will be already starting discussing and designing the next set of strategic plan for the convention, as well as the new set of targets post 2020. And one key lesson is my personal observation, having been with the convention since 1994 onwards, is that we are going to be facing 2020 COP in China with the same message or with a similar message that we actually have had in 2010, that we are unable or we did not manage to meet all the Aichi Biodiversity target that we set for ourselves in 2010. We did have islands of success, but there were lots of gaps. So we need to be a little bit better prepared in terms of designing and delivering our new set of targets. It is during that discussion, as and when we prepare for designing the next level of the strategic plan or next iteration of the strategic plan and the post-2020 targets, some of these elements of looking at giving a little bit more of a legal tool to some of the elements of the NBSAPs, to some of the elements of the biodiversity components, is the one which is going to be important for us to be more effective in designing the post-2020 targets and the strategic plan. And lastly and importantly, even though we do have sectoral laws, even though we do have countries that have specific biodiversity laws, like as I mentioned in India, currently the interpretation and the implementation of some of these laws to a fair extent are independent of the NBSAPs, and countries should start or look at minimizing the gap in terms of that kind of an issue or a challenge. So countries do have an opportunity, even though they have submitted the revised NBSAPs to the Secretariat. But then, because these are living documents, countries do have an opportunity to keep them updated, to keep them revised. But giving a bit of a legal backing or a legal, to the NBSAP is going to be an opportunity that we all should make use of and should not be wasted, as and when we prepare ourselves for the discussions, both for the new strategic plan post 2020, as well as the new set of global targets post 2020. In this regard, as I mentioned, 2 or 3 documents are being put out by UNEP. There is going to be a document, as I mentioned, about the full assessment of the post-2010 NBSAPs that will be available in the next few weeks. We'll certainly post it on the NBSAP forum as and when the document is ready. The document which we made this particular presentation on, or this presentation is based on a report that we are going to be publishing in the next 3-4 weeks from UNEP, where both myself and Tom King has been the authors of this particular paper on legal preparedness. That also will be available. But also we are looking at preparing a similar kind of a guidance tool as and when we are preparing ourselves for COP14. But that's going to be a few more months to come. So with that, thank you very much, both on my behalf and on behalf of Tom King. Both our email IDs are on the screen at this point. If you have any questions or comments after this particular webinar, also we will be more than happy to engage with you as much as we can. Thank you very much.
Many thanks, Dr. Bala, Mr. Mobegi. This is a really interesting and relevant topic for our NBSAP forum members. I am sure our audience enjoyed the presentation. I want to invite our participants to share your questions, doubts, and comments, or raise your hand to participate in the Q&A session. Please use the control panel of the GoToWebinar platform. We can open your microphone or read your question depending on the connection and your preference. Let me check out if we have questions. Hold on. We have one raised hand. I'm going to open the microphone. Ken Inam Ula. Can you hear us?
Yes, I'm there. Thank you so much. First of all, I would like to thank you all for this elaborate presentations. It's not a question, rather a comment, if I may.
Please go ahead with your question.
The comment is basically when you talk about target 5 on reducing loss of natural habitats and target 12 on extinction, and then target 14 on redressal mechanisms, we are doing a lot of things in isolation. If we look at the developments going on globally, we see that the same things can also be addressed through the REDD+ process. Because in there has to be a national REDD strategy which takes into account biodiversity conservation as well. Then there is a feedback grievance redressal mechanism we are going to develop in the readiness phase. So if we can sensitize that to biodiversity conservation and NBSAP implementation, we will have a complementarity of both the processes.
Okay, Diego, can I respond with you?
This is pardon?
Go ahead, Mr.
I couldn't get you, please.
Okay, that's a very valid observation. That's a very valid observation, and I'd like to thank colleague in terms of giving that particular link to REDD+. Because for those of you who follow the REDD+ discussions, may probably recall that it is only after 2-3 years, once we had the REDD and REDD+ discussion started, that people started looking at biodiversity as an important element of the discussion. Forget about having a policy or a framework related to biodiversity, because to a large extent in the initial phases of the REDD discussion, biodiversity was completely on the sidelines of the discussions. But you are right, because unless we are going to be mainstreaming some of these issues and sensitize those kind of stakeholders, we'll be working on these parallel policies in parallel. And that is why kind of a legal backing to some of these would help, because that can actually pull a lot of these pieces together.
Thank you, Dr. Bala. Go ahead.
Thank you. It was just a suggestion, but we have to keep in mind that most of the stakeholders for NBSAP implementation and monitoring are the same as those of REDD+. When we talk about degradation, we talk about deforestation, we talk about natural resources, they are common to all.
Correct, that's very correct.
Yes. And if I may add to the process, to the answer that Bala has provided in this regard, initially Bala mentioned that we are working on some additional documents that will be available in time regarding legal preparedness, and this we are doing in cooperation with other organizations, and part of the content of that document will include the REDD+ process and how parties can draw linkages to both processes and enhance the processes at the end.
Thanks, Tom.
Thank you for your patience for listening to my comment. Thank you so much.
Thank you very much. I have another hand raised. Hold on. Jorku Giflu, can you hear us?
Yes, please go ahead.
Yes.
Go ahead with your question. Let us know which country you are connected, please.
I am connected from Canada.
Okay, go ahead with your question, please.
Yes, thank you, Bala, and the other presenter for a good presentation. My question is, Bala, you have mentioned, rightly so, repeatedly, that NBSAP is a living document, or NBSAP should be a living document. But on the other hand, as the theme of this presentation, this webinar, implies, we need NBSAPs to be backed by some legal rules. But the legal rules or the law need to be a stable one, need to be in place for some reasonable period of time, whereas living documents such as NBSAPs, they could be changed anytime that the need arises. How do you reconcile this fluidity or change in NBSAPs every time the need arises with the need for the law to give some certainty by being stable for some reasonable period of time? And the other related question is, do you legislate all the elements of the NBSAPs, or do you have to specifically identify some of the elements and then proceed to give those elements some legal backup by legislating? Thank you.
Thanks, Vaku. I'm so grateful that you're up and listening to us early from Canada. And certainly a very, very sound legal question coming from the Secretariat. Essentially, I mean, the thing is that there is no one-size-fits-all approach here, because you rightly said that NBSAP is a living document, which means that it should be constantly updated, revised, and be up to speed with the changing conditions, both internationally and nationally. And that is a very valid point. But on the other hand, the moment you are looking at a legislation or providing a legal backing or legislating elements of it, then you actually are going through a process which is going to be time consuming in terms of legislating the same, but also more time in terms of revising the legislation once it has been adopted. That is a challenge for many countries, including, for example, in India and Sweden. So what we are trying to say is not to say that all the elements of NBSAPs need to be legislated, but it is that backward and the forward loop that needs to be found in terms of countries. Because as I mentioned in one of my comments, a lot of countries base their NBSAP principles, programs, and policies based on certain sectoral laws. But there is hardly anything that actually is taken back from the experience of implementing NBSAP to look at how that particular legislation can be better implemented or can be better interpreted in terms of its future compliance. So that is one element of it. The second element of it is that parts of NBSAPs, wherever there is a possibility or an opportunity, we can look at not just having a legal framework like a law, but it can even be a regulatory framework. It basically can be done at the country level. So certainly there is no one-size-fits-all, and the intention of our presentation is not to say every element has to be legislated, but then providing a legal backing gives a little bit of an opportunity for stakeholders and especially the streaming elements to be a little better addressed, rather than the current status where a document like NBSAP is updated with enormous effort and cost, and then people forget about it unless they are trying to write the next national report in terms of what it is and how we're going to respond. So no one size fits all in terms of how do we do it. It depends on the national condition, but we are free to use different approaches.
Yeah. Thanks.
Thank you. We have some questions, written questions. Let me just read one of them from Gina Amezquita. Can you please highlight more on the other legal tools that may be available to countries to ensure implementation on NBSAPs?
I mean, other legal tools are the current and the existing legal instruments that are available at the national level. These can be sectoral laws, these can be, species-based laws and regulations. So those are the ones which are the other legal provisions that are available in general.
Good. I'm going to read another one from Marcela Torres. I'm going to open the microphone. Marcela, can you hear us?
Hello?
Hello, can you let us know which country you are connected, and go ahead with your question. Thank you very much.
Everybody? Hi, can you hear me?
Yes.
Yes, Marcela, go ahead.
Yes, we can hear you.
Hi. Well, I'm calling from Chile, And I have a question that may be a bit specific, but I was wondering about legislation regarding ex-situ conservation, because recently throughout the world there have been many complaints and petitions for animal rights regarding the treatment of animals in zoos. And zoos are supposed to help to conserve biodiversity. But there has been a huge movement against zoos lately. So I was wondering if there is an international standard that could be considered in the NBSAPs, for example, or should this be considered at all within the NBSAPs?
It's a very, very pointed question. I mean, thanks a lot for asking it. Not many NBSAPs actually have even references to zoos as a Ex-Situ repository of biodiversity. Because still a lot of NBSAPs only consider the gene banks and the kinds of the zoos and arboreta, not so much in terms of the Ex-Situ conservation part of it. But very specific answer to your question is yes, there are international guidelines that are available in terms of Ex-Situ collections, their management, their exchange and movement of species across zoos for various purposes. And there are quite a few organizations, including, like, say, for example, there's an organization called the Zoo Outreach Organization, and there is a World Federation for Zoos. Actually, they provide a lot of guidance and support in terms of some of those legal and policy measures, more specifically with respect to the species-related ex-situ conservation. But their link to the NBSAP process, honestly, has been relatively weak.
Okay, thank you very much. I appreciate it.
Thank you very much. We have a right hand from Kathy Mays. Let me 1 second. I'm going to open the microphone. Kathy, can you hear us? Okay, it seems like we have some issues with the audio. I'm going to read the next question in the questions tab. A very interesting lecture, and thank you very much. This is from Lucas Rutina. The guides shared during the lecture will work well at a country level. I am wondering how one can use the same to harmonize NBSAPs for a region, say Southern Africa, or part of a region, say, for example, the Cambago-Zambezi Transfrontier Conservation Area that covers 5 countries, Angola, Botswana, Namibia, Zambia, and Zimbabwe.
Okay, good. I mean, see, the thing is that what regions have done historically has been to develop regional conservation management action plans. And this specific regional entity that is cited here is actually one of the most studied and most researched area in terms of that part of the region, the Southern African region, in terms of having transboundary cooperation and regional cooperation. And there are many, many examples, Latin America, Africa, Asia, Europe, in terms of ecosystem-based conservation action, ecosystem-based biodiversity strategy and action plan, not specifically looking at political geographical boundary of a country-based system. And the experiences so far for quite a few of them have been quite positive in terms of countries looking beyond their national interests in terms of protecting ecosystems. And this particular ecosystem that is cited here is a great example of where countries have come together to protect this ecosystem for the last several years.
Thank you, Dr. Bala. I have another hand raised. Just let me 1 second, from Elena Stambowska Castilla. Hello? Can you hear us? Hello? Okay, it seems that we have some connectivity issues. I'm going to read another questions. Meanwhile, NBSAP talks about protection to traditional or customary knowledge, but there are also various applications for intellectual property rights that depend on bioresources. How can NBSAP address this conflict?
Very valid question, and unfortunately, not many NBSAPs address this issue more concretely or specifically. Let's say, for example, we have very few NBSAPs that speak about the implications or the relevance of intellectual property rights with respect to data, with respect to scientific data and information. So these are the kinds of cross-cutting issues that NBSAPs need to be considering, but for various reasons, we have very, very few NBSAPs. I don't remember even having seen one that specifically speaks about some of these issues, which actually is a little unfortunate. But we have already started discussing some of it in the context of the convention already. For those of you who have been in Cancun, would recall that a major part of the discussion, difficult discussion that we have had, both in the context of the convention as well as in the context of the Nagoya Protocol on Access and Benefit Sharing, is exactly the issue of publicly information, gene sequence data and information on the intellectual property rights and access and benefit sharing issues. So currently, we do not have NBSAPs that actively consider the issues, and until the NBSAPs consider them, we will not have any kind of a guidance or an action plan coming specifically at the country level. But hopefully, by 2018, when we have the next MOP of the Nagoya Protocol, we'll have a little bit more of clarity in terms of dealing with the IPR issues with respect to some of those points. Tomkin, do you have anything to add?
In addition to what Bala said, as the issue on intellectual property as regards to the NBSAP process has really long been ignored, and for the first time it was given a major thought in Cancun, as Bala mentioned, and getting into the legal preparedness process, it's one of the areas that any new laws or amendments to laws that will be undertaken by countries will need a large concentration and focus on. And this will need that countries start focusing their intellectual property laws as regards to other biodiversity issues, given that other environmental areas have already been given consideration. It will not be, I think, a major difficult process in implementing at the national level, but it will first need consensus at the international platforms, and we look forward to COP14 and the MOPs for Nagoya and Cartagena protocols to continue the process.
Okay, thank you. I'm going to open Akim Mawape. I'm sorry, the last name, I don't know how to spell it. Akim, can you hear us?
Yes, I can hear you. Thank you.
Okay, can you let us know where country you are connected, and go ahead with your question. Thank you very much.
Yeah, I'm connected from New Zealand. I just wanted to find out if there has been any assessment on the actual implementation of NBSAPs, because normally there is countries revising their NBSAPs without even implementing them. So has there been any assessments in that regard, or maybe just any best practices as regards to their implementation? Thank you.
Thank you for that question. Essentially, there's been no assessment of implementation of NBSAPs, but then countries are required to submit what are called their national reports, that are reports of implementation of the objectives of the convention periodically. And the fifth national reports were submitted recently by the countries, and currently more or less all the countries have submitted the fifth national reports. That report actually is more like a progress card or an assessment of actions being undertaken for implementing the convention. We have few countries that actually have related the implementation of the realization of the objectives of the national biodiversity strategies when they were developing the national reports. But several countries actually keep these two documents independent. So I can't say that all the countries have done an assessment of the NBSAPs, not many. But then the national reports actually are the kind of assessment reports for what countries are doing in implementing the objectives of the convention, not essentially the NBSAPs, because there was no decision of any COP to look at assessing the implementation of an NBSAP per se.
Well, thank you.
Thank you, Dr. Bala. I'm going to try to open the microphone again from Kathy Mays. Hold on. Kathy, can you hear us? No, I think we have some problems with the audio. Meanwhile, I'm going to read another question from Elena Stanskovska. She says, where can we find the document related to legal preparedness and how long before it is ready?
Okay. We should have the document ready in about a month's time. And we put it on NBSAP side. It's ready, but we're just doing the final bits of cleaning up the text, and then it will be formatted, and then will be posted online as well.
Okay, thank you. Let me check out because we don't have more questions written, and no more hands raised. Okay. To the participants, just to remind you that you can send the question through the questions tab in the GoToWebinar, or raise your hand in the control panel as well. I have the hands of Worku. Go ahead.
Yes, sorry for coming back again. I saw we have got a few minutes, so I was wondering if you can use them. Thank you for for the response to my first question, Bala. I really appreciate. Yes, there's nothing that we can have that fits everyone. Definitely, we need to proceed case by case. In that context, then, in the ideal world, of course, if NBSAPs have some sort of legal status or force, that would be great. That would allow and empower relevant stakeholders and sectors to take part in the implementation of NBSAPs. But in the real world, of course, there are a number of cases where NBSAPs do not have any legal backup, with the exception of some of the elements in the NBSAPs might have their roots in the sectoral laws, biodiversity-related laws that that country might have. But in the absence generally of a law that backs up or that gives NBSAP legal status, is there any other mechanism where we can use to make sure that NBSAPs will be implemented and will be implemented in a way that make a difference or that make an impact in favor of biodiversity conservation? Thank you.
Thank you, Goku. Very interesting question, but also a little difficult question. A large part of it depends on the context in which, or the country in which we are discussing this particular element of it. Because, like say, for example, take a country like Japan. Japan is one country where, any policy, any administrative order, any framework, legal, regulatory, administrative policy, the kind of importance or the kind of status these documents have is more or less like a law when it comes to implementation.
Yeah.
So it is not essential that you should only have a law to implement certain things, because in that country, even if it is just a kind of a notification that comes from government, it has a status or it is treated equally like a legal instrument. So that has been the kind of the approach that the country has taken. And that makes it a lot more easier for countries like Japan to deal with issues much more better, because, like say, for example, they've already done, if I'm correct, 7 revisions of their NBSAPs already. And then there are so many administrative orders that actually have the same status like a law when it comes to implementation. But unfortunately, we do not have many countries where we have a similar kind of a situation when it comes to having the status of an administrative order and the status of a legal instrument are completely different in terms of their implementation options. And that is where we run into difficulties and we have problems. So two or three things could be possibly be done, and that completely rests in the hands of the nodal or the focal point ministries, which are the ministries of the environment. First is to enhance the subject matter of biodiversity to the same level as SDGs on climate change. Because if you do it, it gets a lot more of political support. So the more the political support, the better for you to deal with the implementation. So whether you have a law or a policy, the more the political support, the better for it to be pushed forward. And certainly you take climate change. Even though just in about 2 years we have 144 countries who have got their laws and policies, but still we have a large number of countries, for example, including in India, where we do not have a law, but there is only a policy on climate change. But the policy, to a certain extent, has more stronger focus of implementation than a law. So the first and foremost, and that is, as I said, completely in the hands of ministries of environment, because I mean, it may be a politically an incorrect comment for me to make at this point, because even though the ministries of environment to a large extent deal with climate change and biodiversity, biodiversity always gets a step furtherly treatment when it comes to climate change, compared to climate change. Because it's the same ministers who go for climate change negotiations who give so much of importance to climate change, they actually do the same kind of importance to biodiversity, whether it is nationally or internationally. And that situation has to change. Once we have that kind of a change coming in, even you have a notification, even you have an administrative order related to sectoral elements of an NBSAP, we actually can effectively move forward implementation of biodiversity.
Yeah, thank you.
If I can add to Bala's response, another mechanism that we maybe didn't really capture in our presentation is the use of courts and tribunals and other advisory bodies in this regard, given that they have a very significant role to play in the interpretation of not only the laws, but also the policies that are being implemented in instances where the issue is not specifically sanctioned within the law. So here the courts can be involved in disputes settlement to hear the disputes related to the implementation of the NBSAPs, and that will be one of the ways that through interpretation and the study decides that decisions of the court can be taken as having a legal nature, then over time there will be some form of a customary law that is established at the national level that this issue as relates to the NBSAPs has got a legal backup, although it's not provided for in national legislation, for example. And that will be one of the mechanisms that people and other stakeholders can be encouraged to take upon. And also we should note that the courts and tribunals can also apply a wider interpretation of the existing laws, which even though they don't specifically provide for, let's say, a certain issue covered by an NBSAP, the wider interpretation on the protection of the environment provisions of the Constitution, for example, will end up coming round and covering the NBSAP process. And so the court process can be one of the mechanisms that can be largely utilized in this regard. Yes.
All right.
Thank you very much. I think the time is over. Many thanks again, Dr. Bala and Mr. Mobegi, for your time, and thank you all for your participation in this webinar. Not sure you have final remarks, Mr. Mobegi, Dr. Bala?
Nothing from my side except to say thank you very much for all the participants who have stayed with us, and we certainly enjoyed speaking to you. And once the papers are ready, we will certainly circulate it on the NBSAP forum as well.
Okay, thank you very much.
Nothing from my end, but nothing from my end as well, except to say thank you to everyone for your participation and engagement.
Thank you again. Please check out our website, nbsapforum.net, to get a list of resources provided by this webinar. You will be also able to get a PDF copy of this presentation and the recording link to our YouTube channel when you can see the entire presentation. Stay tuned for our next session in our March webinar series at 23rd March on legal tools to support connectivity and transboundary conservation. Remember, this is going to be happen 23rd of March at 8 a.m. New York time. More information in the NBSAP forum or on our social media accounts in Facebook and Twitter. Remember, register or update your profile. Send us your thoughts on webinars, topics you would like to discuss in future sessions. Diego Ochoa from the NBSAP forum. I just want to say thank you very much again for your attention. Feel free to send us your comments, suggestions, and recommendations. I hope you all enjoyed this session. Have a nice day or night, and hope to see you soon in the next session of the NBSAP Forum webinar series. Bye-bye.